Ultimately, if there's two contracts signed, whichever one is dated first is actually the legally enforceable contract. But a lot of times we're looking at an assignment fee of ten or $15,000, and it's just faster to go get the next deal. If you find yourself in this situation, connect with Creative TC.
What do we do if escrow has been opened at two title companies?
There's so many different things can happen. A lot of times sellers will engage in multiple contracts with various wholesalers because they've made different offers, or somebody comes along with an offer that's $7 higher. I joke, but you make a slightly higher offer and the seller is fickle and goes and switches. And unfortunately for everyone involved, it complicates things quite a bit. Now, whoever had the first signed agreement is the one who's got legally enforceable rights. So if you sign with me yesterday and you sign with somebody else today or tomorrow, my contract is first enforceable. The others are null and void and of no effect unless and until mine cancels. Now, you can sign a backup or a contingency contract, but still, that's just acknowledging that the other contract exists and has first right to close. Sellers don't have a right to back out of a purchase contract. They have agreed to sell, and it is the buyer's prerogative on whether or not to move forward. That's what the inspection period is for. So ultimately, if there's two contracts signed, whichever one is dated first, even to the second, whichever one is dated first is actually the legally enforceable contract. Unfortunately, we also run into if it gets too far too fast on the second contract, like if they just have cash and they're ready to close tomorrow, no title insurance, anything, lock and load, then yeah, I mean, what are you going to do? You got your contract signed 2 weeks ago, and then somebody came through with cash and closed in 2 days, and it's too bad, so sad. Yes, you still legally have a right. You can pursue that in court and chase people down and sue to cause a reversal of the sale, but you're going to spend, 3 to 6 months and probably six to $40,000 in legal fees to get that done. Now, all those fees are somebody else's problem if and when you win, if they have the money to pay you back. But a lot of times we're looking at an assignment fee of ten or $15,000, and it's just faster to go get the next deal. So unfortunately, when somebody's able to close faster, then you're SOL and it's not worth chasing. But if you can defend it actively before it gets that far, communicate with the other title company, communicate with whoever's involved, and indicate to them, hey, I have the first contract. Mine is signed first, mine's legally valid. Yours is not valid. Notify the title company. They should not close that transaction. That doesn't mean this, the buyer can't go open escrow somewhere else that you don't know about again and keep trying. So you need to notify the seller. Seller, you cannot do this. I have a legally enforceable contract with you. I intend to close. We're moving forward. You need to notify anyone else you've signed contracts with that you've signed mine first and that those other contracts are invalid. Under threat of lawsuit, you've already violated our contract here by engaging with somebody else. Do I need to bring in my attorney or is this resolved? Like, you got to feel out the situation and see if that's enough, or if you need to send a demand letter from an actual attorney saying you violated contract, you've entered into a contract with somebody else under such and such penalties and damages. We are ready to proceed. Please acknowledge in writing and show evidence that you have canceled or notify the other parties that you've signed with that you've canceled. The other thing is you can start a lawsuit process and file what's called a list pendens. That's a pending lawsuit in the county public records, which will block any sale until that list pendens is lifted. A little bit lesser method of protecting your purchase is to file a memorandum of contract on the public records or a first right of refusal. If you can file anything against the property in the meantime, then a title search should pull up that that encumbrance, your encumbering title, only if you have the right to do it. But if you can encumber title in that fashion, and a title company does a title search, they will see that. And if it has your contact info, they can reach out to you and say, hey, we need you to lift this. And you can be like, no, I'm not lifting that unless they pay me off, or I'm not lifting that because I intend to close. And if the seller refuses to sign closing documents, you can sue them for specific performance, take them to court. Again, is it worth it? Make your own decision. Take them to court. If you win, a judge will award you the house through a court order. And then any legal fees you've spent thus far would be deducted from the cash that they receive at close of escrow. So, one more time, if it's if low or no cash to seller situation and you're going to spend 10 to $15,000 in court and 3 months doing it, What's your upside? If you have a big enough upside to make up for that, that the seller doesn't have enough cash to pay you back your legal fees, yeah, you can win a judgment against them, but you're not going to squeeze blood out of a turnip. So if it's a deep, profitable deal, good for you, chase it down. But if somebody signs two contracts, the first one is valid, and the only way to enforce that is to notify people to file a memorandum against the property if you have permission. But that's a little bit weaker than actually taking it to an attorney and filing a list pendants, but you're going to spend several $100s, if not a couple thousand, just to get it that far. If you find yourself in this situation, connect with Creative TC. We're not attorneys, but we can speak to your specific situation and help you understand the specifics. We are consultants. We help people make informed decisions. We will point you towards attorneys for any official actions that need to take place. But the consult with an attorney may not be fast, and you may not have enough context to really make it meaningful. And that's where we come in. We provide that value, the pre value, to prepare you so that you can be effective if and when you engage an attorney. When I engage an attorney, I'm doing all my research first so that when I get my minutes with the attorney, they are high value minutes and I'm asking informed questions. So I'm looking for just give me the gold nuggets, give me your specialty knowledge so I can make a good decision here and move forward the right way. I don't need you to train me about real estate. I don't need you to train me about what my situation is. I'm going to bring all my own research to you, present my case, help me understand what my options are. That's how you make the most value out of a situation. And we can help with that.